thank you everyone for being here. My name is Mark Leckington. I'm the Vice President of Affordable Housing Professionals in New Jersey. We've had a bit of a trying morning in pulling this all together. I know I was very fortunate to and glad to hear Lindsay's voice because she's lost power at her house, and she's our the brains behind the operation here and making all this work so smoothly. So we'll keep an eye on her in chat, make sure she's still around. But thank you, Lindsay, for all the effort and putting this all together. And I'm hopeful that you can stick around and that this doesn't cause any problems today. As I said, I'm Mark Leckington, I'm the Vice President of Affordable Housing Professionals of New Jersey. I am sitting in for Ed Schmier, who couldn't be with us today, the president of the organization. He wishes he could. Unfortunately, some personal obligations have prevented him from being with us today. And I am happy to guide us through what will probably be a very brief annual meeting. This is something that's required by our bylaws as an organization. We'll go through a few presentations and then we'll jump right into the panel discussion. So please bear with us as we work through that. If you should have received a link to a package, an agenda package for the membership meeting, and we are going to just be following along with that. So the very first order of business is the recognition of an outgoing board member. Randy Gottesman, who I think many of you know either through the organization or through his professional work, has stepped down from the board, and he is going to be spending a lot more time with his family and in a retirement life. And we could not let this meeting happen today without a little bit of recognition for Randy's involvement and his impact on the organization. I believe he's been a founding member of the organization since it was developed, but his biggest impact has been since 2019 when he took over the treasurer's role at AHPNJ. His impact on the finances of improved the stability of the organization continually. He's been instrumental in setting up some very careful money management practices and working on very thoughtful pricing for the events and guiding a lot of the discussion about finances and fees that are charged. And he's also taken the time to look for more ways for the organization to earn money through CDs. And if you're young, that's not a compact disc. That is an investment opportunity. And through money market investments. And these things have been really helpful for the organization as I said, in making sure that we're financially stable. In addition, Community Grants and Planning and Housing, which is Randy's firm, has been a steady sponsor of AHPNJ for over 10 years. The time that he has dedicated both personally and professionally to this board and the organization will carry on for many years. And as the board wants to thank him for that involvement and all the time and energy and money that he's dedicated to this organization. And we wish him well in his as he works on his golf game and other things in his life. And with that, we're going to move over to the next topic on the agenda, which is the AHPNJ Affordable Housing Professional Certificate presentation. I'm going to turn the mic over to Frank Piazza from Piazza & Associates.
Good afternoon, everybody, and welcome. My job here is to introduce Lakia Nicholson, who has been the Senior Program Coordinator at Rutgers University Center for Government Services and working with the AHPNJ for the last couple of years, about 3 years now. And we really appreciate all that she's done to help improve the program and move it along. And during her tenure there thus far, there's been a significant increase in the number of people who are making themselves availing themselves for the certification program. So Lakia, welcome, and I'd like to introduce you, who will then I'm assuming. Tell us all about your graduation. You have to,
Oh,
there you go.
there we go. Okay. Good morning, everyone, or good afternoon, rather. Thank you, Frank. Congratulations to all the AHPNJ graduates. Rutgers Center for Government Services would like to congratulate you on your professional journey and let you know that we're inspired by your committed excellence as you continue to be the best in your industry. Um, Next slide. I want to thank the AHP instructors for your unwavering dedication to the program. Your expertise and skill level, I'm pretty sure, is much appreciated by each and every student and contributes to their ability to go out into this industry and be the best that they can. So thank you. Next slide. I want to apologize in advance if I mess up anyone's name, but we'll start. We had a total of 30 graduates. So we'll get started. Sonia Adu Velices, Shelby Blair, Joseph Capano, Bernadette Kokoro, Nathaniel Distinct, Kimberly Felice, Talia Greenwright, Christian Gould, Raina Harris, Steve Heisman, Renee Hill, Jessica Krinchenberg, Kathleen Corey, Patrick Leverton, Lori Leonardo, Ashley Macaroon, Emily Christine McIntosh, Faith Moore, Jane Meles, Christian Novoski, Karen O'Keefe, Caroline Ritter, Audra Rodes, Desiree Romero, R.T. Shavakmur, Angela Sliffer, Alicia Torres, Kelsey Traazi, Taquan Williams, and Samuel Jodis. Congratulations, and we wish you the best. Please continue to educate yourself with your continuing education credits. This is just a reminder that you are due 20 credits every 3 years. If you have any questions regarding your 20 credits, please feel free to reach out to myself, and we will make sure that we lead you on the right path to continuing your journey. Thank you.
Thank you, Lakia. I'm surprised to see. I know I teach a couple of these classes, so I know that they've been very, very well attended over the last couple of years. But it is so humbling to see so many people continuing to go through the and take advantage of this opportunity. And there's a whole bunch of folks on there that I've gotten to know very well from both classes and professionally. So I'm so happy to see. I'm not going to name names, but they know who they are.
And so
Um,
far, the class continues to increase. So last year, I think we had, for the same graduation and meeting, we had about 23. So it continues to increase. So congratulations to all.
Fantastic. Thank you. And I think this is probably, I think it's fair to say this is going to be a big year for the classes. I think we're likely to see some changes coming out of DCA
Yes.
on what constitutes a administrative agent and an MHL. And we're looking forward to working with you and the rest of the instructors and the right state folks to help, make modifications and improve that
Bye.
process.
Thank you.
All right. So I think that there are a couple of present. If you're interested in looking over the full annual meeting packet, there's some committee reports that are in there. We're not going to go over them in detail. Well, you can certainly review those on your own time if you'd like to. And we're going to just jump right into the panel discussions, if that's all right with everyone.
One more thing, Mark.
Sure.
We do just want to acknowledge the board members who who were unanimously elected to serve, and those were Mary Beth Lonergan, Frank Piazza, Marilyn Tickton, and Brian Rappaport. And
Thank
I
you,
will put a
Lindsay.
link to the annual report in the chat so that people can have access to that if they're interested.
Thank you. And to be fair, Lindsay did remind me I was supposed to do that, and I did not make that. I did not get that in my notes. So thank you for the reminder on that, Lindsay. You keep everything running like a tight ship.
Oh, and
It-
one more thing, sorry. I will be breaking in occasionally, just like I'm doing now, throughout the panel discussion with some poll questions. The questions this time around are not necessarily relevant to the discussion we're having today, but for people who are seeking continuing education credits, it's important to answer the questions so that it's confirmed that you're here and paying attention during the presentation. So I'll do that every 20 minutes or so.
Thank you. Appreciate that. Okay, so in addition to being helping us through the membership meeting, I also have the distinct honor of being our moderator for the panel today. And we've got a great panel. This is if you're a housing nerd like I am, this is your dream cocktail party. These are the best minds in this, as far as I'm concerned, in the state of New Jersey on the topic of affordable housing. We've got representation from attorneys, from planners, from administrative agents. And I think this is going to be a really interesting conversation. And it's a little bit of a departure from our normal kind of approach to webinars. I think traditionally we tend to like drill down into a focus and like really kind of get into the weeds and and dive deep in some of the topics. This time around, we opened it up. We were looking for questions from you all, and you did disappoint. We got a bunch of questions submitted that we're going to be using to kind of like jumpstart the conversation. Consider this like the sort of a jump off point, and I'm encouraging the panelists to just to treat this as much more of a conversation than it is like static set aside presentations. I'm also going to go do away with the formality of that that first 10 minutes where I stumble through describing everybody's history and and all that sort of stuff. So I'm going to ask the panelists when it comes to when you're at your first opportunity to present, if you wouldn't mind just giving us like a couple of sentences about to remind everyone who you are and where you're from and what brings you to the kind of the world of affordable housing in New Jersey. So to get started, I've got a long list of little topics and conversations, but I think it might be worth kind of just giving everybody taking a little snapshot of where we are in a very changing year. We've got new regulations that have come out at the state level for the A4 or the new Fair Housing Act, round 4. It's nice how they lined it up with the actual round, the piece of legislation. Makes it easy. We've also got some big changes. We've also got the expiration of the UHAC affordability controls, administrative and affordability controls that are those are going to expire a month and a day from now, if I'm not mistaken. And we've just recently, I think, if a couple of Friday nights ago, you probably got your inbox blown up with numbers from DCA. So there's a whole lot to talk about, and I think that there's certainly no lack of topics for conversation today. I think the Q&A is open, so if you have a question or follow up to something that you hear about, or you want to see or you have something entirely new to add to the conversation, not 100% sure we'll get to it, but we will certainly make every attempt to do that. And if we don't, please, we will take this back if it might become the subject of another conversation at a later date. So certainly, please use the Q&A if you have something that you want to add to the conversation or a question. I'm going to do my very best to channel Ed Schmier for a moment, though. If he were on this call, he would interject and he would say, "Mark, remind everybody that we are not providing legal advice here, and that this is a conversation that we are." That the folks that are here today are not the legislators. They're not the folks that work at HMFA and DCA that are rule writing. They're not people from the Attorney General's office. They are professionals that are working in this world alongside all of us. And what they say today is certainly worthy of follow-up and confirmation through your own resources and professionals. But again, this is not intended to be, we don't expect to see any fair share plans with quotes from today's conversation. I'm not sure how far that's going to get you. So please, your mileage may vary, or whatever those little disclaimers are at the end of the car ads on the radio that I can't ever understand. All that applies here as well. But yeah, let's get started. And forgive me, I got too many windows open here. So,
Hey, Mark,
please.
would you mind just starting off with, do you have a sense of when HMFA and DCA may be coming out with their emergency rules? If you would just go into that just a minute.
That's a great question. So the emergency rule that Mary Beth is talking about are some updates to the Uniform Housing Affordability Controls. These are the rules that govern the sort of the day-to-day creation of affordable housing units and the income certification process and a number of other like sort of nuanced tasks within the affordable housing framework. Those rules expire on December 13th, if I'm not mistaken. And in order to, and so they'll basically like literally go away and expire if a new set of rules is not promulgated and reissued. So the New Jersey Housing Mortgage Finance Agency has been convening meetings and stakeholder groups to help inform edits to those to the changes, and we are fully expecting to see a new round of edits or a new version of UHAC to be released shortly before December 13th. The timing is just so challenging that it will not take the form of a traditional rollout of regulation, in that there will not be a comment period, as I understand it. And that probably would have already started if that were even possible. There will not be a comment period, and they're using a emergency provision within the rule writing scheme that allows them to update the rules without that comment period. So based on the conversations that I've been a part of, it sounds as though that the rule changes are going to be modest, but addressing some of the more significant sort of shortfalls and we'll call them cracks in UHAC, where developers and others have figured out like little workarounds and, for lack of a better term, hacking UHAC. So we're expecting to see just a very modest set of rule changes in this first edit, and then we've been promised that sometime next year we're going to see a more substantive and more thorough kind of deep dive under the hood version of UHAC changes. Yes,
Thanks, Mark. And just to, hi, everyone. Good afternoon. I'm Mary Beth Lonergan. I'm a planner. I'm a partner at Clark Payton Hinds. I wanted to just touch base, and thanks, Mark, for covering HMFA's proposed emergency rules for UHAC revisions, Uniform Housing Affordability Controls. And just to remind folks, DCA, the Department of Community Affairs, will also be promulgating, we understand, emergency rules for administrative agents, spending plans, MHLs. So there's, stay tuned for that. I think, as Mark said, I think many of us hoped we would have seen draft regulations already, but I believe, Mark, I think I heard you say we're hoping that we'd see both sets of regulations possibly mid-December. That's actually when the new law is requiring the regulations to be promulgated. So stay tuned for that. But thanks, Mark.
Quite welcome. The questions that I've got that I've been to start this conversation aren't necessarily in any kind of order, although I do have them kind of grouped together. One of the early questions that we got was about the concept of rental units and the expiration of controls. And I think I might be reading between the lines here a little bit with the basis of the question, but I believe the focus was on round 3 units that are going to come off controls and have this, you know, the requirement that a future council at that time decide whether or not the controls are going to be renewed. And it would seem to me that the question is, will those units count? You know, is there an expectation that a renewal of those rental unit controls in the 4th round would be would help create credits for the 4th round or not? I'm just going to kind of throw this one out there for anybody that may be willing to talk about it. And certainly, we're not looking for any definitive answer here, but it's more of just a, you know, maybe poking holes in the or supporting the idea of it, or even poking holes in the idea of these units being creditworthy in the future. And as a follow-up question, that same person asked whether or not, if they were to be counted, is it likely we'd see recertifications of everyone's income in order to get those additional credits?
Well,
You
I'm
wanna go-
sure.
You want to go, Mary Beth, or you want me to start with this? Because you know my feeling on this particular issue.
Yes, I do. So thanks, Rick. Let me just say, Mark, you couldn't have started off with a
Mark, you got me fired up. It took 5 minutes to poke this topic, and
So I know that the person was specifically asking the question about rental extensions of controls, and it's a really different world than extensions of sale unit. So just in case the person wanted to talk about, we will address the rental issue, but for sale housing, and you know, we've got, as Mark, as you said, we have a really good panel, and I'm sure we will have some opinions may be confirmed and others may be, oh no, you know, that's not how I look at it. But so I think it's clear in the new legislation. I'm going to refer to it as A4, as everyone knows that was enacted back in March of this earlier in this year. I look at the clear allowance for extensions of controls for the 4th round. And it's the easier part of the conversation is for sale units. The new law sets forth the range of time periods for those extensions of controls to be credit eligible for the 4th round. So, Beth, do you think there's anything else we need to talk about for sale extensions, or?
No, I agree. I think it's pretty straightforward that if the controls are extended during the round, or for the round rather, you'll be eligible for credit, and you may even be eligible for a bonus credit.
And actually, Beth, thanks for saying that way. So to get a 4th round extension of controls, the controls would have potentially had to expire in the 4th round.
I don't think the legislation takes it that far, but it says scheduled to expire. I think the expectation and the practice is it's got to expire during the round for which you're extending the controls, or previously, if you're looking for essentially new credit for the unit in the upcoming round.
I agree. Thanks. So now we're going to. So the issue with extending controls on rental units, I'm going to let Rick just jump right in on that. It's going to be a very complicated issue. Clearly, there are, you know, 3rd round sites that may or may not. Like I'm not sure how many 3rd round controls for rentals could expire in the 4th round, but let's Rick, feel free to go with this.
The easy part has been answered, which is if you can extend a rental credit, you're going to get credit for it as part of the 4th round. There's no doubt about that. That's easy. The question is, how do you extend? And to this point, UHAC's language is terrible in terms of what it says. It requires that and let's just set the table here. You've got a project. It's a a traditional rental project that had deed restrictions imposed upon it. Let's call it, mid 1990s, so 30 years are coming up on some of these projects now, and that will continue to happen over the course of the fourth round. And some of them didn't have deed restrictions at all, because frankly, we did a very poor job, I think, just generally with our record keeping in the early parts of the affordable housing creation. But if you followed the UHAC deed restriction in creating those controls, it contains a provision that provides that the controls may be released by the township. And if the township elects, I'm paraphrasing, I'm not reading the rules, but if the township elects to release, they need to do so by ordinance. So the question then becomes is, what does that mean? Can a township simply elect to extend over the objection of the landowner? Because again, we're not dealing with for sales here, which are a much simpler process. You're dealing with a landlord that entered into a deed that by its terms said 30 years, at least 30 years. So there's an expectation, at least, and just to provide some background, Rick Hoff represented developers my entire career. So there you go as to where my prejudices are coming from. But this is the side of the aisle I'm always on. So on the landlord side, at least 30 years to them meant 30 years. So at the end of 30 years, it was at least the expectation that would be some sort of negotiation at the end of that 30-year term for, are we going to extend these controls? Okay, if we're going to extend, what's the compensation for it? That is not necessarily the universal response on the municipal side, because there has at least been, and Beth knows it well, at least one instance that I'm aware of, and probably others, where the municipal position was, well, no, because UHAC has the language that say may elect, that also means they may elect not to give you anything. They just simply extend the affordability controls for 30 years and take the credits. Now, my view, of course, coming from the developer side, and is that that's not what was intended by UHAC. Simply to argue that point means that you shouldn't have had 30 years in the first place. They should have just been perpetual. And if they were perpetual in nature, that's easy. And the developer landowner knew what they were getting at the time. But there is a great uncertainty in this field, as on the rental side. What do you do at the end of that 30 years? Are they burning off? And if they are, do they need to be replaced to maintain the certification from the prior round? I think most people would argue that no, there's no requirement in the Fair Housing Act or any iteration of COA regulations that require a municipality to replace units whose deed restrictions have expired. But certainly that's an argument to be made if, in fact, that's the language that's in the UHAC deed. It only makes sense that they would be able to extend without compensation because they have to replace. Otherwise, I don't know what the language means if not to require some type of give and take between the developer and the town. But UHAC provides no roadmap for that. There's no provisions in there that say what must be done, what must be paid, what the values, none of that. So here we are at the end of these terms, and there's no answers as to how we go about this. And I suspect at some point, a court at some point is going to weigh in on this, because one of these cases is just going to go up, because the town won't give, and neither will the landlord, as to what that meant. So, Mark, Mary Beth, I wish there were a clearer answer on this, and certainly Josh, Mike, Beth, appreciate their input on this. But I've been digging in this issue for the better part of a year, and I don't have any better answer now than I did when I started. Someone in a robe is going to, unfortunately, probably have to make the call on what is required at the end of these 30 years.
Yeah, thanks, Rick. And Michael, I see you unmuted yourself, so I'm going to hand off to you. But going back to that compensation argument, the 30-year subsidy on an affordable housing unit, a rental affordable housing unit, is astronomical. So the idea that even if compensation were offered, that you're going to make a developer whole to subsidize another 30-year term is pretty incredible. Mike, did you have something you want to add?
Well, so I've dealt with Mr. Hoff on a lot of matters. I represent exclusively municipalities, and so does our firm, primarily in affordable housing, and we do some planning board in general, municipal work as well. So there's some level of agreement with Rick on some of the issues, primarily that it's gray and it's going to be for a higher court to decide at some point. I do think there's some case law interpreting that provision of UHAC to require an affirmative obligation on behalf of the municipality to release the controls. So by implication, if we have that unilateral discretion, it's a municipal position that we have in most instances, depending on what's in the deed documents, what's in the settlements. I mean, some developers have negotiated that at the end of that 30-year term, we will adopt an ordinance within a time certain to release the controls. So if all developers agreed that we didn't have that discretion, they wouldn't probably try to get that in settlement agreements when they're negotiating their agreements. But that's my position on it. In terms of the compensation, I think developers do get compensated. They get compensated with 80% market rate units at the beginning of the process. That's a density bonus. That pro forma continues in time, and the rents go up over time. So when I've been told by a number of financial experts and developers themselves that when they're doing their pro forma and they're submitting it to a bank for financing, it's not like the bank bakes into the cake what happens at the end of those 30 years. They're looking at the math up front and kind of envisioning it being in perpetuity. And the word perpetuity is interesting to me as well. It could have been that the legislator wrote it to be in perpetuity, but they are the various bodies of law, I shouldn't say the legislature, but they didn't, and it's not as though it's the same thing, because a municipality can elect not to extend controls. They might do that because they don't want to go into the unit and bring it up to code, which is a requirement under the extensions of expiring controls theory. So I think it's appropriate that they have discretion, particularly when there's an outcome for extension or a price to be paid for an extension from the municipality's perspective. So I think we're just on complete opposite ends of the spectrum. I view it as a precious resource that really is for the region's poor, more so than it's for the developer's pecuniary interest. And we should be doing what we can in those instances to protect that resource and continue the affordability control. So I think that's the municipal perspective. Rick's a very good lawyer. I'm sure he's made a lot of good arguments with other attorneys on this matter, and I think a court's going to ultimately have to call it sooner than later.
The one point, and I'll be brief, the one point about the density bonus being the consideration, the thing that's often lost on the municipal side, not lost, but the argument doesn't get raised, is that these rental communities, they need reinvestment. So at the end of the 30 years, you're not talking, these units don't go on infinity without necessary and substantial capital improvements. So the notion that these units just live on without any upkeep is not correct. There is significant investment that needs to be made in these projects, and right around that 30-year mark is where you're making those serious capital investments. So the idea that this is free for the developer to do and extend is not financially accurate. But again, to your point, Mark, dollar for dollar, it's a tremendous cost of a 30-year restriction. So we don't know what the answer to that is in terms of what is just compensation for that extension and what that requires. But like Mike said, and someone, presumably smarter than us is going to have to make that call at some point.
How about a softball question, Mark?
Well, I think Frank had
interject there, Mary Beth, if I might. Regarding the sale units, which we kind of just painted over real quickly on the way to rental units, one of the things that Rick just mentioned is also true for sale units, and it's kind of easier to extend the controls. We should mention, though, that a unit does not live on forever in the condition that it was first sold in, and ultimately, and this is nothing to do maybe with the legislation, more to do with my own emphasis, is to encourage municipalities to set aside money to help owners of sale units for the rehabilitation or refurbishment of units at the end of the first 30 years of the restriction. So just my kind of spin on the sales piece of this.
Yeah, I'll jump into that just really quickly, just to say I totally agree, Frank, and I think I think the regulations as upheld by the New Jersey Supreme Court in the 2015 Mount Laurel 4 decision clearly allows for extensions of controls. And, you know, I see that tied to COA's regulations at the time. And I think everyone knows they're in the third round set of COA, Council on Affordable Housing Regulations. As a really quick aside, this new law keeps a lot, even though COA has been is now defunct, is eliminated. COA board, you know, COA staff, if you will, the COA agency, the COA regulations live on, and they live on. I look at it that they live on regarding extensions to controls. Frank, exactly what you were just you know saying. I think there is a minimum required rehabilitation per unit rehabilitation amount that should be spent. You know, the unfortunate thing is this rule is over 15 years, you know, so the dollar amount is quite low, relatively speaking. So I think towns should, you know, seriously think about a reasonable and defensible per unit amount for renovating the units before they can be counted as fourth round extensions, credit extensions.
Megan, you're muted. Or we can't hear you.
Who's speaking?
Um,
Oh, Frank, you're muted.
I think Megan was
Oh.
trying to.
I was gonna say Megan has her hand up.
Oh,
Still can't hear you, Megan.
yeah, Megan, we can't hear you.
Come back. Maybe, yeah.
I was just gonna say, Mark, I think we're having trouble hearing you. At least I am.
Oh, sorry about that.
That's good. That's good.
Yeah, my apologies. Again, if you want to give it another shot.
Megan, can you come in through the
Any chance there?
Yeah, yeah.
You can hear me? So Mary Beth, were you speaking of the rehabilitation program for, were you talking about the maximum caps on units just now, or with that they're in the regulations about how much needs to be spent for a unit to be counted towards the present need obligation and applying that to extension of controls?
No, thanks, Megan. I was talking about sorry, it'll just take me a second to find it's NJAC 5. This is COA's third round regulations, that some of the regulations were upheld by the Supreme Court. I think it is 5:97 dash. So no, I'm not talking about the rehab, that
Okay.
$10,000 amount, but that's a whole different issue.
Okay.
I'm talking about the extensions of controls where, don't quote me, I think it was like about an average of 30,000 per unit needed to be expended between low income and moderate income units that were extended.
I'm not recalling that, but I will check it out.
Okay.
And I just wanted to get back to the original question about, does the household need to be recertified when the controls are extended? I believe that was a question, and they do not have to be recertified. So if someone is living in an apartment or owns a home and the controls are extended, there has historically not been a recertification process there. And I would also, along those lines, in a homeownership scenario that Frank was talking about, where the investment may be needed toward the unit, even if the current resident is not income eligible. So if we were to get some additional guidance in the form of regulations from maybe DCA or HMFA on this, it would be helpful to see if can you compensate a homeowner for rehabilitation of a unit, even though they're not income eligible anymore, for in the effort of preserving this affordable unit.
Mary Beth, I wonder if you're referencing the market to affordable provision in the regs?
I was, thanks, Mark. I was referencing that stated per unit average expenditure for rehab, and so now I'm on the section. So it's 5:97-6.14 extensions of expiring controls. And you're right, it doesn't name a specific dollar amount, but under A4, it tells us if a unit requires repair or rehabilitation work in order to receive a continuing certificate of occupancy, blah, 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 the municipality shall fund and complete the work. So that's where I was tying in just the municipality should really seriously consider providing some funds. You know, and Rick, I think you said it, and Mike, I hope you agree that it would be a negotiation with you know, what's needed. You know, think about it. There's in inclusionary developments, you're going to have you could have market units in the same building. Let's just say there's, you know, 150 units across the site, maybe 6 different buildings. And so maybe a proportion of a new roof or new HVAC, you know, upgrades. It could be, you know, some proportionate share of renovating or, you know, providing a whole new roof on that structure. That's my that has been my guidance to my municipal clients.
Well, and I think that's right. I mean, so to Mr. Hoff's point, you know, it's not free. That's true of any development. Even if there are no affordable units, the developer would have to reinvest over time. So I do think the lion's share of that should come from the landlord. But, you know, the regulations envision units being brought up to code, but in the rental project, they're kind of brought up to code internally. So there's not a tremendous amount of municipal expense associated with that. So I do think the better practice and frankly, the right thing to do is to come to some level of understanding with the developer on what renovations can credibly be tied to the extension. I think Mark's point initially was, well, how do you quantify the cost of a restriction over 30 years? It's millions and millions and millions and millions of dollars. So I don't think that's the proper framework for negotiation. I do think Mary Beth's framework is the appropriate one, which is, well, what can we do for the project to ensure its continuing viability?
And jumping back over to the home ownership column on this concept for a moment, I feel like we don't have that, you know, within the, as Mike just said, within the rental side of it, we've got this mechanism that makes sure that the units are continually up to code through local policies and ordinances about re-inspections and those sorts of things. The ownership side not only doesn't have that requirement until a unit is sold, but if you read the reg between the regs, you realize that there's almost a disincentive for the homeowner to make investment in the property, because it's those additional dollars that they put into that unit are not going to be realized with a very rare exception in their eventual sale price. So they don't really have that incentive to, you know, replace the carpets and cabinetry and things like that that may not have been the highest quality when the unit was built on day one. So I feel like the problem's a little bit harder to solve on the ownership side too. Josh, I'm anxious to get your take on what you've heard so far on this topic.
We've got a poll question.
All right, I gotta take my poll questions. Hold on, guys.
Same here. Same.
It won't let me click it off the screen. It's saying I can't vote.
Maybe just minimize it.
Yeah, your vote would have been just, never mind. I was gonna say offset by Rick's, but just a joke.
I don't have much more to add. I mean, I think, you know, obviously we've talked about this a great deal. It's very clear that we want to see more of these affordable units be have their affordability controls remain in place. But I think we obviously recognize that, you know, when we're talking about homes that are 30 years old, that they're going to need some reinvestment. That's clearly a priority that's in the A4 legislation to try to make sure that some, you know, preservation of these homes is a priority. And we know that towns have municipal trust funds that are, you know, that they can use some of those funds to do just that. So, you know, I think we're, you know, when it comes to trying to, extend the rental units, obviously it's gonna be a little bit more complicated because you're not interacting with the owner themselves and instead are interacting with an owner of the person, or excuse me, the owner of the development where, lower income households are living. As far as the for sale units go, I think that is another place where we really do want to see towns actually making sure that the affordable units remain in sound condition and that there's some compensation for, maybe doing some rehab. There's some other upgrades to the homes, especially when they're 30 years old. What the legality is of getting into the back and forth with Rick and Mike about whether, what does UHAC say and is it legal or is it not? I think UHAC, I think it says what it says, and I think they're probably right that eventually at some point somebody's gonna have to make a call, unless we get some different language in the forthcoming UHAC regs. I don't know. We'll see what happens. We're gonna get those in another month and we'll see what happens. But as of right now, I think it's just very clear that either way, whether it's legal for you to do it unilaterally or not, I don't think Fair Share Housing Center is really interested in seeing affordable units be preserved that aren't getting additional reinvestment, because then they're not going to be really good housing for people to live in for the next 30 years.
Well said.
For next 40 years.
Mark, I just want
one-
to give I'm sorry, just a tip. Is one of the challenges I've seen for towns. This is not necessarily specific to A4, but just while we're talking, I have some towns that, well, every time they get a sale unit, they extend the controls. They do another 30 years of controls. And in a lot of ways, I feel like that's a best practice. It means that you're never in danger of losing the affordability on a unit, having something expire all of a sudden. But the problem is, it also means that you're never able to generate extension of expiring controls credit because the unit always is expiring 20 or 30 years from then. And so while I think it in a lot of ways is the right thing to do, it's actually not helpful from a compliance perspective. And just as a side note, one of the concerns I have with the extension of expiring controls rules, as well as how the legislation is written, it's also a disincentive to ever do perpetual controls, to negotiate that with the developer, because if you're doing perpetual controls, you're never eligible for another round of credit. And I think that's a really important and unfortunate disincentive that's been written into the world in which we're all trying to operate. So.
Thank you, Beth. That is like I've had so many heated conversations about that idea of renewing starting the controls over from day one on resales so many times. And you're right. It seems like a best practice to preserve the long-term affordability of it. But if that deed restriction doesn't expire until the round after the one that you're planning for, then who's to say that you're ever going to get credit for it as a continuation? So thank you. I had a note to bring that up, but I'm so glad you did, because it's a very fair issue to raise. We had a lot of questions surrounding the new numbers and whether or not there was going to be some sort of opportunity to dispute the numbers, what that might look like, and if certainly what that timeline might look like. And I'm more wondering if anybody's given much thought to that, or if anybody's got any inside intel. Josh just unmuted himself, so I'm ready for the answer.
Well, yeah, I mean, it's the town's, I mean, it's very clear in the legislation that it's the town's obligation to say what their number is. These DCA numbers were very clearly from the legislation and from their face are advisory. So there's not a method to challenge what the DCA has done. You can come up with a number that's different than that, and then if somebody wants to challenge your number, I mean, obviously, if you're going to come up with a different number, you have to justify it. You can't just say, well, I think my number is lower, or I suppose higher, but I think you actually have to come in with a number that's justified, and then it'll be up to either Fair Share or to a developer or some other interested party to challenge what the town has done. But there is no mechanism to challenge the DCA numbers as such. They're non-binding.
Could I Rick, do you agree with that, that you can't, there's no opportunity to challenge DCA or a town's acceptance of DCA's number?
Well, again, if the town is accepting DCA's number, at that point, it becomes the town's number. And they've adopted what DCA has done, which they're free to do, as Josh indicated. What DCA did here is they took a first crack at interpreting what the statute requires by way of a municipal calculation. A town is free to, you know, take a different interpretation of the statute and come up with its own number that they can then defend to any potential challenger. I think the difficulty for a municipality to stray from the DCA numbers, it's not impossible. They certainly could do it. But one thing that's not particularly open to dispute is the total household creation. So that's a very simple formula in the statute about how we came up with the total number. And so then the hard part about these numbers that we spent 41 days in a trial on is how does the numbers get dispersed to the individual municipalities? So again, just by way of example, Mercer County, it's one thing for West Windsor to come in and say, well, my number is much less. It's 200 units less. Well, that's not a complete enough answer if I'm going to object to that, because the 200 doesn't go away. So who got the 200 that West Windsor is now disclaiming? So from my opinion, it's not enough for a town to come in and say, well, my number was miscalculated. There's a trickle down effect to that needs to be answered, which is, well, if DCA got West Windsor's number wrong, well, where does the mistake get corrected? Is Princeton picking up more units? Is Plainsboro picking up more units? Like, how does that work? Because they're a regional number that's allocated. So it's an incomplete answer for one municipality to come in and say, you know, DCA got me wrong. Here's what I think I am. It begs the next question, which is, all right, well, what's the effect of that in the region? Because you can't just diminish the regional obligation without explaining where it went.
Well, so, I mean,
I knew this was coming.
I'm going to be measured in what I say, just because a lot of this is ongoing attorney-client privilege type of stuff. But I think the statute makes clear that all these disputes are supposed to be resolved in a month. If you have, particularly think of like a Bergen County, if you have a bunch of municipalities taking a bunch of municipalities, how is it possible to sequence them in 30 days and resolve all of them? It's literally not. So we could talk about reallocation, but as a practical matter, it's either that's how you fight the fight and everything has to happen in sequence, or you completely violate the statute. You can't have both. If everybody's going to take contrary positions, you can't resolve all those disputes. Literally, you can't do it in 30 days. It's not possible. So we'll see how it all shakes out. I have no idea. It was poorly written, poorly conceived. 30 days is pie in the sky. We'll see, you know, Rick and other developers, especially hot municipalities, are going to have 6, 7, 8 developers and fair share involved. And that itself, that one municipality wouldn't resolve in 30 days, let alone an entire region. So I don't know exactly how it's going to play out, but I know it's not going to work.
Well, I mean, the one thing you're missing, Mike, I think, is that in the statute, it very clearly calls for the possibility of consolidating similar challenges. So if the towns are all saying that their number is different, they have to, first of all, explain how they came up with the different number. And so my guess is it's going to be one of the 3 allocation factors, because it really can't be anything else. The rest of the numbers are known. They've been known even before DCA. The top line number was already known, you know, 6 months before DCA even published this number. And so if there's 10 towns in Bergen County that are all coming up with a different allocation factor for, you know, using data for the developable land factor, that could all be consolidated and done together, with the program literally just saying, no, you're all going to use this one data source. And it very well may be that the program just says, no, we're going to use what the DCA did and everybody's going to use DCA. You know, I don't know that it needs to be done sequentially for everything.
Well, so, I mean, so a couple of things. So first of all, I think it says the same municipal determination may be consolidated. So if you want to read that to be plural, I guess you can make an argument, but I think it's a difficult one to make, and I don't know how you consolidate a case with different municipal entities taking positions contrary to one another, because it's not like they have the same interest in it. It's not like they're taking the same position. So how do you consolidate that? I guess we'll see in live time. But my read of that is, if you have 5 objectors to one particular town's municipal determination that you could consolidate those 5 objections into one to the extent they have the same nucleus of dispute. I don't know how you do that with multiple municipalities and competing interests. I really don't.
I'm going to jump in here only to kind of take us back to a really important point that when AHPNJ did our seminar a few months ago, I think I was a broken record then, and I'm going to be a broken record now about the timing of your municipality accepting a number, whether if you're going to accept the DCA number. Remember the deadline. Your municipality must adopt a binding resolution and submit it to the program. And remember, the program is the Affordable Housing Dispute Resolution Program. It has been established established in the new law. I'm not aware of this program coming out with procedures, a web page for towns to literally submit this binding resolution, but that deadline is January 31st, 2025. And what's really, really important is that you submit that binding resolution within 48 hours of adoption. Don't wait until January 31st, 2025. If you adopt this resolution on January 10th of 2025, or even in December or whenever, it's got to be submitted within 48 hours of adoption. And I am not kidding you. The law tells us that you would automatically lose immunity from a 4th round challenge. So I'm going to leave it there. Please get your binding resolutions in on time. Again, within 48 hours of adoption. So sorry, I wanted to just go back to that issue.
Thank you. That's really helpful. It's been January meetings tend to be a little different for municipalities too, with sometimes they have reorganizations, they have a late meeting schedule that month for other business. So it's a particularly challenging time to hit a target.
And Mark, to Mary Beth's point about the program, I just happened to, there's actually a number on the court's website that you can call and ask questions about the program. And I called this morning just to see, because that very question I'm wondering, which is, okay, I'm ready to, I'm a municipality. I really want to get a jump start on things. Can I submit early? Where do I do it? And they spoke to the secretary for the program, who had no further information as to the program and its procedures. So as of this morning, you just go on to the New Jersey Judiciary,
okay.
And they give press releases. It's how you found out who the program actually was, the members of the program. And they have an email and a phone number there that I'm sure they're happy I'm mentioning this to a panel of God knows how many people. But don't bother calling, at least today. They don't have any further update as to the procedures.
I was going to ask Lindsay to patch the operator in to our panel here.
If you ask, tell them Josh Bauer sent you.
Oh boy.
But AHPNJ will be the first to tell all of you when we are aware of this program coming online, with new procedures and a working website to be able to accept an uploaded binding resolution.
Very good. Let's see, I'm going through some more questions here. I know, Mary Beth, you had a softball. I feel like we've been diving pretty deep into the weeds here. I don't know if you want to throw out a softball, but I've got one that.
Go ahead with your softball.
All right, so this is the question. The person that submitted this question is Mark Leckington, and this is popped up just recently because of some conversations I've been having with developers, and that is, that there seems to be a big trend right now for doing special needs set-asides within our affordable housing obligations. And you know, if you spend any time in that world, you realize that the income levels and maybe the size requirements for that population don't necessarily jive very well with what you would consider to be the bedroom distribution rules of, you know, 1s, 2s, and 3s, and the different income level rules. And I'm wondering, do you all see this as sort of like a little standalone subset that should be treated differently in the rules, or do you see this as something that needs to be like folded into the and when I say rules, I'm talking about the pricing, the sizing, all those sorts of things within that sort of core affordable housing obligation, or if you see these two things as being treated separately?
I'll take a stab. And I forgot earlier, my name is Beth McManus. I'm a principal at Kyle McManus Associates. We do general planning, municipal planning, affordable housing, redevelopment, et cetera. So in terms of having a mix of, I think the question is basically a mix of family units and one or more units that might otherwise have been a family affordable unit converted to, say, a group home. My expectation, my experience is that these are going to be two different types of affordable housing units that happen to be in the same project, but are subject to their own requirements. So the family units are going to be subject to the 1, 2, and 3 bedroom requirements, but the special needs units or unit, group home, whatever it may be, will not be. And the same for the income affordability requirements. So the family units should be subject to the very low, and moderate income units, income requirements, whereas the group home might all be very low income requirements. And those very low income units would certainly help the municipality meet the obligation, but they're certainly not going to contribute to any family obligation.
Thanks, Beth. I totally agree with you. And just as a further, I'm dealing with this very issue right now where I have and I think Frank might be assisting on this too, where we have a for sale inclusionary development, and the on-site affordable for sale units are just what you're saying. You know, they meet the 1, 2, and 3 bedroom. We've got the income split, but it's the very low income. There's not going to be any very low income for sale units on site. There will be a group home off site for very low income to address that development's very low income requirements. I will say also, actually, sorry, and Frank, you might be involved in this one as well. I actually have another inclusionary development also for sale, where there will be for sale, very low income for sale units. I think I can say it's American Properties. And I wish them luck. Frank, I wish you luck finding eligible homeowners to be able to purchase very low income for sale units. And actually, I mean, I'll be happy, you know, to offer Frank and I to, you know, kind of report the next time, you know, we have another AHPNJ seminar on how it's going. And Megan, I'm not sure if you're starting to see very low for sale units as well.
Yeah, I'm Megan York. I'm from CGPNH, Administrative Agent. I also forgot to introduce myself earlier. And just, we do have very low sale units, and knock on wood, have absolutely no problems selling them to buyers and have some for some time. So that's currently not a problem for us. But what I heard a different response from you and Beth. I heard Beth say, her response was, it's inclusionary. There should be the income mix and bedroom mix for the inclusionary units, and the supportive housing can be all very low, but that doesn't meet the very low requirement for the project. And then I heard Mary Beth say, we're going to take away the very low and say none of the inclusionaries have to be very low. We're going to do it with supportive housing.
I wasn't saying that they would not meet. I wasn't trying to distinguish that they might not meet a very low income requirement. I was just separating that perhaps the municipality wants to put the very low income units in that special needs housing. My point was, if they're looking for family very low income units, they wouldn't qualify. That was all.
So if what scenario that I'm running into is, say there's a 10-unit affordable requirement and 5 of the apartments have been set aside for supportive housing, does that mean that there's going to be no family very low units in the other? Or do you, and I think that maybe that was also what Mark might have been trying to address. So just do not do any family very lows because they're going to be filled with the supportive housing. And I think what I would recommend is that much like the negotiation we were talking about for expiring controls, is that there are a lot of details around this issue and that they should be addressed during the approvals phase and not after, when the developer says, okay, I've got my 10 units, I'm ready to lease them up. It says 5 supportive housing with no thought to how it was going to be priced. Even what are the maximum rents for those supportive housing units? Are you using the UHAC rents, or is it a negotiation with the supportive housing provider to pay what they want to pay? There's a lot of things that need to be worked out. What are the affirmative marketing requirements for the supportive housing units that are in an inclusionary project? So a lot of things that need to be addressed, early on in the process.
To add to that complication, there's also vouchers in some of these units sometimes too, which would require the contract rent to be FMR. And Frank, I'll turn it over to you.
No, I just wanted to follow up on what Mary Beth and Megan mentioned, and that is basically that our experience right now is we have far more of very low sale units coming online than I had ever anticipated. Having said that, we're not having necessarily a problem filling them now, but I would caution all of us that the way that you need to weigh this or to evaluate this program is not how many people are buying them now, but what they look like in 10 or 15 or 30 years, because the people who own them might, in many cases, not have the resources to maintain them. That's been my concern more than the purchase arrangement.
That's a great point, Frank, and I think it's something kind of what Megan was saying that needs to be thought through as part of the approval process, and that maybe we're not waiting 30 years. Maybe it's going to be a municipal assistance. And think about it. It could be affordability assistance from remember, affordability assistance is statutorily required. So I think towns, are going to have to think about potentially having a pool of their affordability assistance to 10 years down, 20 years down, 30 years down to assist these very low income homeowners.
Is there something specific in the legislation, or are we waiting for UHAC 2.0 to deal with the very low income unit mix, the unit mix for the very low income units, I should say, which is not in the Fair Housing Act?
Oh yeah, no, it's the new law specifically tells HMFA you must amend UHAC to include the very low income. Statutory.
Not only to include it, but first of all, to include it as a project by project regulation, and also, which is that makes it different than the low moderate split. Low moderate split is project by project. The very low, there's nothing that says it has to be in every project. Well, and then there's not only that, but then the distribution of those very low units, are they 1s, 2s, and 3s?
We will see. We will see. I hope AHPNJ had enough influence with HMFA to have, no, seriously, to have a reasonable approach.
We need to direct that question to Megan and Mark to see how far they got with those.
That's right.
We had a related question from Wyatt Grant in the chat. He said, to clarify, group homes and supportive/special needs units may be used to meet 50% family housing requirement for rent. Question mark.
May not be able to meet the family requirement. You cut out for a second. So if that was the question, special needs in any form is not eligible to meet the 50% family requirement. So not group homes, not supportive housing units. And Mary Beth, I saw you raise your hand. Do you disagree?
So I think the vast majority of how you said that is true. So I'm going to focus on that first. And because that was even something I wanted to respond also to Megan, that I agree with you, Beth, that generally speaking, it's going to, the special needs supportive housing is a different category, different from senior housing, different from family housing. And the new law is clearly requiring you to do 50% family housing, and then 50% of rental. And Megan, I take it that you have to, you as a municipality, you need to be thinking through as part of your plan to have the right very low income distribution, plan wide. Okay, so in those situations where you allow a inclusionary developer to do an offsite group home, you better be sure you don't need those as family very low. So I okay. Now, Beth, I'm going to come back to the what's the word? There are times with tax credit developments, because HMFA, because HMFA literally says it's either 5 units or 5% of a tax credit job should be geared to households at risk of homelessness. So there are times, and I can tell you, for instance, I'm working with a developer now, and Fair Share Housing Center has agreed to count those supportive units for and they happen to be 1, 2s, and 3 bedrooms as family units. So that is the only exception to the rule, if you will.
I'll throw another exception out, and I think it could be the veterans preference, the reservation of veteran preference units in family developments. I think that's another special population that is outside of the special needs category.
I totally agree. Yep.
And Mary Beth, is it your understanding that because that mix exists in those 13% very low income units, that they count as family units? And if you were to just simply make them all 1 bedrooms, that wouldn't be able to make that argument?
So what it comes down to is, and Mark, I think you even, or maybe Megan, you alluded to, how do you affirmatively market the units? And so if they're in the, let me just say, if they're in the typical special, Department of Human Services world, where it's a reference from, hey, Division of Developmental Disabilities has a client that needs to be served. Once we go down that path, I think that's special needs. But in this at risk of homelessness, I think the household, so it's a combination of they meet the 1, 2, and 3 bedroom UHAC. So even a 1 bedroom should, I think, get credited as family units, in the sense that they are they are still I think they are still affirmatively marketed through UHAC. Oh, actually,
The law reads something like available to families with children. That's how I think the law talks about this. So I think that's sort of like you could move into the 1 bedroom, a mom and a kid could move into that 1 bedroom. So I think that's kind of the way to think about it.
I totally agree.
But
Yep.
it wouldn't be based on being open to the general public, in the sense like you were referring, I think, where you were going, because basically those homeless folks are not going to be in the lottery.
Well, so do you know that for a fact, for a tax credit developer, that they would, so I'm literally just talking about low income housing tax credit funded, where the 5 or the 5% of the units for folks that are at risk, either experience homelessness or at risk of homelessness. Well, number one, those deals are exempt from UHAC, but
Or are they?
Can we talk about that next when Mary Beth is done?
I'm done. I'm done. I'm done.
So do we, I'm just going to ask the question. I don't know the answer. Do we have any expectation that UHAC is going to try to bring tax credit projects, is going to apply to tax credit projects? Because that was a significant, in my world, that was a significant issue in the third round, where we think we have projects that are exempt, but in order to generate the settlement that we're all hoping for with you know who, the tax credit projects needed to meet the UHAC requirements, or you had to generally address it in throughout the course of your plan. So is there any expectation that that's going to change?
Mark,
I,
Megan,
I don't see
I
why would it, I think that currently a lot of the leverage that we as administrative agents have in this regard has to do with what fair share folks have included in a whole bunch of their settlement agreements.
exactly.
Because the opening paragraph of UHAC says these don't apply, but for the patching in now, the application of UHAC to tax credit it's not 100%. There's certain things that are more restrictive in the tax credit program, et cetera. So it's not 100%. And there's always been a debate about, I don't know, somebody had a debate about is a lottery or first come, first serve applicable, or those kinds of things. But I think that the biggest problem was plugged or addressed, I should say, when Fair Share included language that at least allowed this. It allowed us to count tax credit units at the 50 to 60% levels that were expected by the town. So when the tax credit developer came and said, well, all of these units are going to be low income units, the town said, oh, that's great. But they were using federal language, which meant that the credit was really beyond, they could be all above 50 and be low income units. And so I think that was sort of the key factor that was helpful. I'm not sure if that's going to be written into any UHAC regulation at this point, or we depend on the settlement agreements.
So, so this is my 2 cents, building off of what Frank, you just said, and what Beth, you said earlier. Going into the fourth round, this is how I think of it. Any tax credit developer, generally speaking, we're still in an era that they are going to need, generally speaking, need municipal assistance for tax credit. Whether it's the municipality purchases land and donates it, or just gives some kind of contribution. We, as this panel and the larger group listening, we've got to ensure that we continue making a tie to any municipal contribution, even if it's just simply a pilot, because these tax credit jobs are required by HMFA to have a pilot, a payment in lieu of taxes. Towns should use that leverage to ensure very low income at 30%, not at least no more than 30%. And, just what you're saying with the other bells and whistles for a municipal fair share plan. Let's call it that way. Whether it's the having half low, half mod with some very low. That is my recommendation.
I don't disagree with you, Mary Beth. The thing that gives me pause is the level of affordability in these projects can have a significant impact on the amount of municipal subsidy that's necessary to get them done. And so I guess my last point would be, I just hope HMFA provides clarity on this issue, and we get clarity on the issue from the program very quickly, because it's going to it could influence how municipalities work with their developers. It's certainly going to influence the contracts that they enter into with them.
Yeah.
Getting back to the very low income ownership model, someone asked a question about how impactful special assessments might be to someone who's making 30% or less of area median income. And I feel like that's probably a great use of affordability assistance, not only for very low income people, but anybody that's in an ownership situation that's in an affordable unit. Is that fair?
Mark, I think that is a great use of funds. And I have run across this, and I've maintained that in order to use it for that purpose, you would need to income certify the homeowner. I'm curious if other people agree with that, that if you're to qualify for assistance with a special assessment and you're an affordable homeowner, you need to prove that you're still under the income limit. And I have met a lot of resistance to that opinion from the people who live in the homes. Yeah.
Oh, to even providing the paperwork and going through the effort.
Yeah.
Yeah, Megan, I agree with you, and Mike, I don't know if you have, as a firm, have started to think about this, but I agree with you because the use of affordable housing trust funds, I think clearly, they have to be for, oh, actually, that's interesting. Maybe the debate is whether the unit still has the controls versus whether the household is still income certified for that, whether it's very low income assistance or just any assistance. Ooh,
Yeah.
I've always been thinking that it's that the person. Oh, actually,
We're not extending controls. This is just a regular.
yeah.
So there is a difference between a unit that needs work and a special assessment. So the special assessment, first of all, could be for the snow that fell, could be for anything. A special assessment is going to be paid by the homeowners. And it's going to be paid for by, with under the direction of the association, one way or another. Now, if a homeowner can't afford to pay it, that's when the homeowner could legitimately be reimbursed or use some of the housing trust funds. But I think that that's a different discussion than whether or not the unit can remain affordable. Because I think when you're talking about what the association's responsibility is in these special assessments, it's going to get done. And if somebody can afford to pay for it, they should. But that's ultimately different than the other discussion we had earlier.
But Frank, what about using affordability assistance through trust funds to assist someone who has, hopefully gained a little more salary? Maybe they're just above the moderate income level, that they themselves who need that assistance to pay that special assessment. I think I'm hearing Megan says they have to be income eligible.
I think it would have to be a different pool of money, not the pool of money to make affordable units more affordable.
Well, okay, yeah, this is we have a disagreement. So, but I did want to, just because I was looking at it the other day, I did want to direct your attention to, there's a new section in the law that is requiring our friends at DCA to establish, so I'm just going to read it. It's a new section 36, and it's that there should be establishment of policies regarding the cost of assessments and fees of planned real estate developments, as defined on, blah, blah, blah. So the cost of assessments on low and moderate income household or housing units. So I thought that was, that could be something really helpful that we could potentially get. Is it PRED, Plan Realist, what's the name of the division at DCA that reviews homeowner association and condo association documents? I think it's called PRED. And hopefully that they will start to think about, I mean, on some level, it almost goes back to, for special assessments, should low and moderate income units be paying the full freight of, maybe they should still, maybe not, but anyway, there's policies that DCA should be looking at the impact of special assessments and fees on low mod housing units.
Well, this certainly sounds like a topic that we could have our own session on, in addition to the special needs topic, which I actually think should be another session, because I think what we're lacking, at least on that conversation, is the perspective of the providers and some of the people that are kind of in the trenches on not only building these units, but doing the long-term supportive services and working through all the extra regulatory hoops that they've got to go through. So I'm hopeful that we will be able to roll out another session on that and have a more detailed conversation just on special needs housing. Anthony Marquetta had a really interesting comment in the chat about the foreclosure crisis. I think he's talking about back in 2008 with how he says he'd be concerned that that very low income home ownership model may create more foreclosures and loss of credits in units. And that's a really interesting point, because I think that there's been some conversation, and maybe maybe out of school here with this comment, but I understand that there may be some consideration to make the fourth round home ownership controls expire on foreclosure rather than be durable, as we had. That was a big change that we got in round 3.
Wow, that's news to me, Mark. Where did you, like, I don't see anything, or I haven't yet seen anything that suggests fourth round controls would be potentially.
My understanding is that there's concern about FHA financing because of survived foreclosure, and that may be getting some traction to change UHAG.
Wow.
And I think that I immediately go to, if the home goes to foreclosure, do you lose the credit? That I don't know anything about how that's thinking that through, because it'd be challenging for municipality to buy a home foreclosure and work through that, especially if they're competing with investors.
Yeah, you'd almost argue that it'd be easier for them to just buy a market rate unit to replace it with than try to win at a sheriff sale or something like that. And also the other sort of nuance to that is that you're almost creating I mean, if a bank were to foreclose and were to lose the affordability controls, the amount that they're going to sell that unit for on the open market, even if it's got major code violations, is likely to be far in excess of their loss on that financing. And it creates a paradigm that scares me a little bit. Let's see, it's tons of questions and comments in the chat. I'm going to do my best to get through some of them. We don't have a whole lot of time left. I've been told by Lindsay that we're as long as we go to 2:30, we're good. But if folks are willing to stay on a little bit longer, I think we probably got another time for another 1 or 2 questions, because I know there's been a lot that we haven't gotten to.
Mark, if you
Yes.
want me to read any of these too and float it to the group, I can do that. Up to you.
Thank you, Brian. I appreciate that. I'm honing in on the comment that Jane Moles made. She said she would love to see a webinar regarding rules regarding developments raising affordable housing HOA fees to market rates. Yeah, I think and there was another comment in the chat about related to that, about the idea that the HOA fees would be a huge burden to somebody on a very low income if everybody were paying the same rate, and it would basically chew up a lot of the available money that the household could afford for housing expense. Yeah, and I think the other thing that struck me when we were talking about that in this last exchange was the idea that the ownership units, if you were to offer an incentive to extend the controls, that money's not necessarily required to go back into the unit but the unit should be brought up to code, right? And we're not doing income certification there, but if we're requiring that anybody with affordability assistance, especially if somebody's requesting affordability assistance to sort of preserve the asset of affordable housing, somehow it seems okay to ask them to recertify themselves, because
Cool.
I guess theoretically they're going to benefit from the improvement for some extent.
Mark,
Rich, do
just
you have a
on
thought?
that point, and it goes back to something Megan said earlier, you're not required to recertify upon the expiration of controls on a rental unit, but you can recertify because the requirement is that the person's entitled to remain in that unit provided they are income qualified. So again, at the extension of a rental control, that person under UHAC regulations is entitled to remain effectively for a life estate, so long as they remain income qualified. The only way to know that answer is to actually income qualify them. I mean, I think there's actually,
Yeah.
Go ahead, Megan.
No, this is when the controls are not going to be extended, and we call it unwinding of controls. The controls just don't end on January 1st and the rent goes up. If
Right.
the household is still within the income limits, it's maintained as an affordable unit until either they vacate or over the income limits. So I completely agree.
Can I make this is one of those kind of suggestion-y things. Maybe Josh can help us out. So one of the things that we've begun doing more often now is working with properties that are decontrolling, if you will, and we go through the process of recertifying folks. And the way that UHAC works is if you're up to 80% of the median, then you get to keep whatever rent level you were at until you're either no longer at the property or no longer at or above the 80%. There's one big, huge hole in all of that, and that's the tax credit projects. There doesn't seem, at least in my experience, there doesn't seem to be any regulation that requires the tax credit properties to provide the same protection to existing low or moderate income tenants.
That's actually, I would agree with you, Frank. There is nothing because if UHAC does not apply to those, and in fact, if you are getting a tax credit, HMFA will actually issue a letter at the end of the controls indicating that there are no longer any controls in effect at the property. So I agree with you. There's a disconnect between what UHAC provides for your typical inclusionary project and what there is for a 100% tax credit project.
Yeah, and ultimately those folks are gonna, those folks who are they might have moved into the project the year before. So there's a good chance that they're still low or moderate. And, unfortunately the rents goes up, could go up tremendously.
I'm going to jump in and just answer. I see Leslie London had a question about if a town thinks it's going to be either asking for a new vacant land adjustment or an update to its earlier vacant land adjustment or RDP. Leslie, I don't think you need to say that as part of the January 31st binding resolution issue. I think you have to say it as part of your housing plan that should be submitted by June 30th, 2025.
So I agree that all the professionals reading that think that that's how it should read, and it's been bifurcated in the past, and we all take a historical bias when we read that provision. It's actually not clear in the statute itself from a drafting perspective, but I do think that's how most people are interpreting it.
There was a question in chat from Candace about rehab and sober housing, whether or not that's going to count as supportive housing. And I'm not necessarily sure if if it's terribly important to get under the classification of supportive housing, but I suspect you're thinking more along the lines of, are they creditworthy? And I do know that that the A4 did introduce SROs as a transitional housing, not necessarily SROs, but transitional housing as a creditworthy endeavor. So I think we're getting kind of close to sober housing and rehab housing, but I don't know of a specific mention in A4 on that topic. Does anybody have any thoughts on that?
Yeah, I'm just going to say that to the person asking the question, definitely take a look in the new law at the definition of transitional housing, as well as within the body of the law. It talks about how to get bonuses for transitional housing, and it has even a couple other requirements. And so, well, number one, well, anyway, I'm going to just suggest that you look there to make sure that the sober or rehab housing can meet the statutory definitions and requirements. It may or may not.
Tom Mertens asks if there's been a discussion about mechanisms or a process to convert rental units to sale units.
That's a tough one.
That sounds like a challenge. Especially if it's a rental unit and like a multifamily rental unit, right? You're talking about condoizing or converting it to a condo, the building. But if it's a sort of a standalone one-off rental unit, I'd say that's probably a little easier, heavier, lighter lift.
Mark, can I just go back to the resolution on the RDP real thing?
Absolutely.
I think in those resolutions, towns should say they reserve the right to do their adjustment, just to be clear and to be sure.
I like that. I like that. And that's free. That is free legal advice right there.
Call it the Mike Edwards clause.
Yeah.
I'm invoking my Mike Edwards clause. I like it.
The only, I don't have any experience about converting rental to sale affordable units, but I will say that it gets extra complicated if it's a unit that the municipality took a bonus credit for, a rental bonus credit for. So if, to the extent that folks are looking at that or may have the opportunity, I would just look to see how the unit was used in their plan, if it was intended to meet the rental obligation or received a rental bonus.
There's a question. Oh, go ahead,
No,
Mary.
I was just going to say, from an administrative agent point of view, I do get those questions every once in a while, and I don't think the rules ever considered that at some point during the 30-year control period, you could switch the tenure of the credit. There is no mechanism to make that happen. There's no discussion of what happens with the current occupant, and so I think maybe upon extension that could be something that's considered, but I generally my standard answer is let's say a landlord no longer wants to be a landlord, so they want to make it a sale unit at year 20. That's they signed up for a rental unit, and that I don't believe that the town has an obligation to facilitate turning that into a sale unit because somebody doesn't want to own affordable housing anymore.
I see Sue Mack asked a question about Sue, the date of it has to be a resolution confirming the acceptance of a number that has to be submitted by January 31st, 2025. So I would not wait. I don't even know what January 31st is. I would not wait for January 31st because you won't literally have time unless you do it the night of the meeting. You won't have time to submit it. So I'm recommending to my municipal clients to definitely think about a special meeting, especially in January, because you have, just like you said, so there may just be one governing body meeting in January, and maybe the other one is just reorganization. So I would plan to either do a special meeting, especially if there's a threat of a snowstorm or no quorum or something. I am not kidding you. It's really important to have a plan to get this resolution done and submitted within 48 hours of adoption.
January 31st is a Friday.
There you go. So
and I don't know
Taboo
what the
day.
big rush is. I don't know what the big rush is, Mary Beth. It's not like there's anybody watching you towns as to whether or not you screw up on the 48 hours or not. I don't really understand the
Thank you,
panic
Rick.
here.
Thank you, Rick. Rick is being facetious. Do not trust that. Yeah.
I have a similar sort of a concern. When the new UHAC regulations are promulgated, there's going to be a pretty significant gap in time between the time that they're promulgated and the necessary changes to ordinances, municipal ordinances. And between that and while that's all going on, we're going to have approvals coming forth from planning and zoning boards. I guess my concern is that the municipalities get a sense of what they need to look out for in terms of applying the rules in the planning approvals, absent, any kind of history of it, absent the ordinance, etc. That, I think that AHPNJ could even, or the planners could come up with a list of things like we did previously that planning boards need to be aware of, or municipalities need to be aware of, because of X, Y, and Z changes that we don't know what they are yet.
Frank, to that point, I think that, again, my suspicion is that the UHAC regulations that we're about to see are going to be applicable to fourth round sites and plans. So what you're having filter through now at local planning boards are still third round sites. I mean, there could be some progressive forward thinking towns that are already pushing forward projects that will provide fourth round credit. I think that's probably the exception to the rule. So I think you're correct. There is going to be this gap, but I don't know that there would be a lot of people falling within those cracks, because by the time the towns get their fourth round plan done and there are projects moving forward under the fourth round plan, they would have UHAC's regs already in place. Because
So
UHAC's regs are going to be in place in
sets of
December.
regulations for some time.
Yeah, I think that's right, because I think UHAC will be a prospective application for the revision. So if you have an old site, again, maybe it comes out reading different, but I think if you have a third round site with a settlement agreement that talked about UHAC, I think it's reasonable to expect that it was the UHAC regs in place at the time of the settlement, not what might have changed at some point in the future.
So it's going to be really important for when we get these projects to implement, that municipalities make clear this is a fourth round, this is a third round, this is a fourth round, this is a third round. So as they leave the planning board and sort of go to our realm, that we are quite clear as to which set of rules we're using.
Well, funny that you say that. So I'm going to say something. I'd love to hear the reaction from everybody on this panel. So you all may know that the new law is setting up that when you adopt your housing element and fair share plan in the spring of 2025, that you just have to have draft implementing ordinances, right? That was shocking to me. And I, kind of building off what you're saying, Frank, I'm going to recommend, I mean, unless I'm just not thinking of a specific situation, I'm going to recommend that my towns adopt those ordinances in the spring of 2025 to implement, because like, remember the municipal land use law, like you can file an application, right? If there's a draft ordinance, to change, a site as for inclusionary zoning, it's like you could miss it. So my recommendation is going to be in the end of, still in the end of the third round, to adopt those ordinances. And if the program ultimately says, Mary Beth, you need to change your ordinance, but that's okay. At least I've got a, the adopted inclusionary ordinance on the books before the start of the fourth round.
I would just say, if you're going to do it that way, to make sure that the ordinance itself only becomes effective upon approval at the program or court of competent jurisdiction. Because the inverse is also true. You adopt it, it's operative, they file an application, now they have a site plan application that was approved pursuant to an adopted ordinance. So I would just make it clear that the ordinance becomes effective upon program approval.
how about not becomes effective, but the planning board resolution says, hey, we're approving you under this ordinance. If the program amends this ordinance, you applicant, you've got to address any program changes. Because I don't want to push off the effective date of that ordinance. That's my bottom line.
Yeah, and what if you're not working with a developer, just to throw a what if out there, if it's an overlay zone or a site that you're anticipating zoning for inclusionary development that's maybe in a commercial zoning district, what if somebody files a by right application for something that is not consistent with your housing plan? You've potentially just lost a site and the units associated with it.
Yep. And I'm just going to put a plug in for Beth and maybe some others on this panel that NJ, the New Jersey American Planning Association is having a panel on Thursday, I think this Thursday, on vacant land adjustment questions. I'd suggest everybody, sign up for that. They're still accepting, because I'm not kidding you. There's one provision about vacant land adjustments that I think I've spoken to 4 people on this panel, and we have 4 different opinions and interpretations of this vacant land adjustment point.
It's going to be the hot topic in the fourth round, just vacant land
is.
adjustments in general. If you don't have one already, I think there is a good chance town's going to move in that direction.
Yep.
So.
I think the last poll question just went up, so I think we are just about out of time. There's a lot of comments and questions in the chat. We're going to certainly save them and share them with everybody. And like I said, this is most likely information that'll help us educate other programs in the future. I want to thank all the panelists. This has been my dream cocktail party conversation about A4 since it came out. So I'm so interested in what you all had to say about a lot of these topics. And I know we had a pretty good continuation rate among everybody that signed in. So it was certainly some engaging content. I also want to thank Lindsay, who, as I mentioned before, is working behind the scenes to make this stuff run smoothly. And we could not do this without her. She's a critical asset to the organization. Also want to thank all of the people that are now affordable housing professionals as of this year, and for going through their sessions and going through that process. And lastly, I'll just wish everyone well. If you have any follow-up comments or questions later as you're going about your day, feel free to fire them off to info@ahpnj.org, and we will certainly fold them into our conversations going forward. And thanks again for everybody participating and all the panelists today. Thank you so much.
And when
Thank
I
you,
click
Mark.
end on the webinar today, there will be a survey that should pop up on your screen asking you about your satisfaction with today's webinar. So please fill it out. We really do look at the results. It is helpful for us to get that feedback. Thank you. Okay, have a great day, everybody.
Thanks, Mark.
Thank you.